All right, welcome to this week's version of Wealth Wednesday. You'll notice that we aren't live right now because we are having so many issues with Zoom and Facebook connecting that I would start the presentation and would immediately get kicked off. Or I shouldn't say immediately, about 10, 15 minutes in, I would get kicked off. So this is, I don't know, my third or fourth try at this. I'm just going to record it, repost it into the group later. Obviously, you won't be able to ask questions live, but go ahead and ask questions in the comments below afterwards. We'll be more than happy to make sure that they get answered. So I'm going to go ahead and share my screen. We're going to jump right into this presentation. Okay, so today we're talking about building a beneficiary plan under the Secure Act. So what is the Secure Act? Well, basically, on the eve of Christmas, Congress kind of pushed this underneath the rug, pushed this into law, and it changed a ton of estate planning stuff and made it much harder to efficiently pass money on to the next generation. And so for our clients, we were changing so many estate plans because of this Secure Act that right off the bat, just ask yourself, how much changed in my estate plan? How much did my advisor bring to my attention that should change from this Secure Act? Because again, it's something where we changed plans across the board. So today we're going to be talking about passing on retirement accounts to the next generation in the most efficient way, adhering to this Secure Act rule. So right off the bat, I want to remind everybody of the golden rule of tax planning. Now, many of us don't want to pay taxes, but assuming we're forced to pay taxes, the golden rule is we want to make sure that we pay taxes when we want to pay taxes on our schedule and not on the IRS's schedule. I promise that paying taxes on your schedule will behoove your situation much more than the IRS's schedule. So again, just remember that as we go through this presentation. And again, this presentation, we're going to be talking focusing just on retirement accounts, tax deferred accounts, IRAs, 401ks, every variation of a tax deferred account, as well as Roth plans, Roth IRAs, Roth 401ks. We're not going to be talking about passing on your house, passing on brokerage accounts to the next generation, focusing primarily on IRAs and Roth plans. Okay, so let's talk about a time before the Secure Act and why it was so powerful, why the rules allowed us to essentially save on taxes and save significantly while passing money on to the following generations. There was a provision called a stretch IRA. Okay, basically what a stretch IRA allowed us to do is to reset our RMD clock in order to allow for tax deferral to continue through generations. Okay, so let's go through an example. Let's say that we have an owner of an IRA. He's 80 years old. So he's past the age of 72 and required minimum distributions are set to begin. Okay, so he's taking an RMD each year. He's got $1 million IRA. That RMD will grow through time. So at 81, he will have to take a larger RMD than he was when he was 80. Okay, so basically what the stretch IRA allowed us to do is to defer taxes, maintain tax deferral while passing money on through generations. So this owner, let's say he passed away, and by the time he passed away, he passed this $1 million IRA, which has grown to a $1.2 million IRA, onto his, let's say it's a son. Okay, the son is 50 years old. Well, basically what happens is that RMD schedule resets, and it resets to a younger age, which means the RMD he is required to take is much smaller now. Okay, so even though the account's grown, his RMD is smaller. Now, let's say this son is fairly well off. He doesn't have a need for that IRA. So he's just taking the required minimum distribution from this inherited IRA each year. Okay, well, then he passes away. And let's say by the time he passes away, he passes this, what was a $1.2 million IRA, but has grown to a $2 million IRA. He passes it on to his son, let's say, which would be the child, which would be the grandson, I guess, of the owner. So this grandson now has a $2 million IRA and he's 30 years old. Well, once again, the RMD schedule resets. So he isn't forced to take a huge RMD from this $2 million sum. He certainly can take more than he is forced to with his RMD, but he doesn't have to, allowing him to, again, defer taxes. And this could continue for multiple generations. So again, when we're talking about some significant inheritances, especially when they're inside of a trust, you were able to defer taxes through multiple generations, constantly resetting this RMD schedule, which was extremely powerful. Well, basically the Secure Act changed this. Okay, they eliminated this stretchability for just about everybody. We'll talk about who kind of still has that ability, but basically it's confined now to one generation, one more generation. Okay, they implemented the 10-year distribution rule. And we'll talk about what that means, but basically now you have to distribute that money within 10 years instead. There's no stretching it across multiple generations. RMDs, the good thing in the Secure Act was that RMDs rose from 70.5 to 72. So now you have an extra year and a half where you can minimize these RMDs. It's about the only good thing in the Secure Act. Okay, and then new classes of beneficiaries and new rules were implemented for each of those classes. So what is this 10-year beneficiary or this 10-year distribution rule? Well, basically, if you inherit or if you pass on an IRA to a son or daughter, or you inherit an IRA from a parent that passed away, you now have to distribute the entire amount of that IRA within 10 years. Now, you can do it any way you want. You can take it all in 1 year. You can take it equal periodic installments through those 10 years. You can do it any way you want, but you have to distribute the entire amount within 10 years. So depending on how much you inherit or how much you give it as an inheritance, this can throw some real tax planning hurdles your way or to your heirs. Let's say that you're planning on an inheritance from a parent, okay? And let's say it's in the form of an IRA. Well, let's say you're 65 and you're on Medicare. Well, if you inherit a large enough IRA and you're forced to take distributions that are large enough from that IRA, it might push your Medicare to higher premiums. Okay, it might throw a wrench in this Roth conversion strategy that you might be planning on. Okay, there's so many extra hurdles that this 10-year distribution put into place. Okay, now recently there was some confusion. The IRS sent out a update letter around this 10-year rule and basically confused everybody. Okay? I believe it's called like B 590B or something like that. And basically this update basically confused people into thinking that you were forced to take periodic payments. So each year through these 10 years, you were forced to take an equal amount. They've since updated that. And they now kind of reverted back to the original rule where you just have to, at some point through this process, through this 10 years, that IRA needs to be completely empty, okay? Most people don't know this applies to tax deferred accounts, but also Roth IRA accounts. So if you inherit a Roth IRA, you have to use that within 10 years as well. Now, there's not the same tax burden for doing so from a Roth, but you don't want to make the mistake of not following this 10-year rule. Why? Well, if you don't distribute this full IRA, this full Roth IRA within 10 years, you have a 50% penalty for what's ever left in this account. So let's say you inherit a $1 million IRA and you don't start distributing until year 11. Well, you're going to now owe $500,000 as a penalty for non-compliance of that RMD. So make sure that you distribute on the right timeline, both with your inheritance, but also have a discussion with your heirs to make sure they know about this rule as well. And again, most custodians, most financial advisors should notify you, but it's not always the case. Okay. And so the last thing you want is to have a Roth IRA that is supposed to be tax-free that you just don't distribute on the right timeline. And now you owe a 50% penalty, 50% tax essentially for not distributing on the right timeline. So basically this rule set, this is the Secure Act, I should say, created 3 different categories for beneficiaries. The first is beneficiary royalty. Okay, it's called an eligible designated beneficiary. For most people, that's going to be a surviving spouse fits into this category, and stretch rules still apply for that surviving spouse. However, in certain instances, there are a few other people that do qualify for this status. A minor child, okay, somebody less than 18 years old, disabled or chronically ill heirs, or an heir that's not that is not more than 10 years younger. Okay. What most people will fit into is this middle bucket. And I'm going to explain kind of the rules and abilities that each of these buckets have. Most people are going to fall into this designated beneficiary bucket. And this bucket, subject to the 10-year rule. So this would be basically non-spouses or people that don't fit into that first category. So if you're giving an inheritance to your 50-year-old son, okay, that would be a designated beneficiary. If you were giving it to a brother that is more than 10 years younger, that's a designated beneficiary, okay? And so we'll talk about what that means for that person. Third category is non-designated beneficiary. Now, these people have the least amount of strategies available. First would be a charity. Now, that's not a huge deal because once you transfer that to a charity, that's essentially their issues to deal with. The big one that we see people making a mistake is naming your estate, expecting that your will decide where these retirement accounts go. And that is a huge mistake. We'll talk about why in a sec. Well, let's just kind of step back for a second and reiterate the importance of naming a beneficiary. So first off, a beneficiary is the person or persons who will receive your retirement account. It steps outside of your will. It has priority over your will, and it won't go through probate. So meaning that there won't be probate fees. The public won't be able to see this account when it gets transferred on and such, okay? Two types of beneficiaries, there's primary and contingent. Basically, if the primary disclaims the inheritance or has already passed away, it goes to the contingent beneficiary. You're going to want to make sure you have both listed on your beneficiary form. Make sure this is spelled out. Again, don't depend on your will to replace this beneficiary form. It technically will, but it won't. It won't do so in the most efficient way. And again, make sure this form is explicitly spelled out. Why? Okay, well, let's go through a few horror stories. And full disclosure, these horror stories are meant to scare you in a sense, but meant to scare you into doing the right thing, okay? Making sure that you don't make these same mistakes. So hopefully nobody is critical of me using a little bit of fear in order to make sure that you have all these boxes checked in the proper way. So Mary Williams dies, okay? She leaves a $500,000 IRA to her 4 or 5 children. We see her 5 children listed on the form, okay? From Cindy to Gerald, okay? Problem is she sloppily filled out the form and didn't specify a percentage for each of these children. So what happened? Well, Cindy, the first person listed on the form, inherits the full $500,000 IRA, even though she knows her mom meant to distribute it each equally. So now if Cindy isn't very honest, she is technically entitled to that full $500,000 IRA. She could take and run with it, not giving her brothers and sisters anything. But let's say she is honest. Cindy just was put into an incredibly difficult situation. Okay, she inherits a $500,000 IRA that she has to distribute within 10 years. Now, she might still figure out a way to try to equally distribute it to the other children, but in the process, put herself into some serious financial planning situations, tax planning situations, because she now has to pull that full $500,000 completely from her tax return, essentially, or have it on her tax return, causing her to owe more additional amounts in tax versus $100,000 to 5 people is much easier to distribute in a tax efficient way. Okay. Another horror story that we often see. This would be for somebody inheriting the account. Okay. They entitled the account incorrectly. So let's say Ted Smith inherited an IRA from his dad, Bill Smith. Now, most people would think, okay, as long as it stays in an IRA, I should be totally fine. It should stay under the same tax status. That's not the case with inherited IRAs. So Ted in this situation goes ahead, takes this IRA and empties it into his own IRA. Again, because either way, they're both tax deferred, right? Well, wrong, okay? An inherited IRA needs to stay as an inherited or a beneficiary account. You cannot transfer it over into a regular account. Doing so would qualify as a full distribution. So let's say Ted inherited a $100,000 IRA and transferred it to his account. Well, now he would owe $100,000 in taxes. He also isn't able to contribute $100,000 in a year. So it's a taxable event and throws Ted into some huge, essentially inefficient tax implications. Okay. What you want to do is title it with something like this: John Smith IRA, deceased, and then their deceased date for the benefit of Ted Smith, beneficiary. And you want to make sure it's an inherited and a beneficiary IRA. Okay. Not just a regular IRA. Okay. Number 3, horror story. Who has the forms? Okay. 30 years ago, Pam signed a beneficiary form explicitly laying out her beneficiary interests. She wanted it given to each of her 3 children. Now, in the past couple decades, her advisor has switched firms 3 times. Okay. It happens. Advisors sometimes switch firms, hopefully upgrading to a better firm. Now, Pam suddenly passes away. And the problem was, during the times her advisor switched firms, her beneficiary forms were lost, not transferred. Now, the entire time, Pam, assuming her advisor is accurately transferring these accounts, actively updating these beneficiary forms on her behalf, she was, unfortunately, she was already passed away, but her heirs received a rude awakening. Because there were no beneficiary forms, her assets transferred to her estate, okay, and had some serious implications. So to avoid this horror story, make sure that your custodian has up-to-date beneficiary forms. Make sure your advisor has duplicates, and make sure that you even have duplicates, okay? And make sure you include it in your estate planning form folder to make sure that your beneficiaries are as up to date, your beneficiary forms are as up to date as possible. Okay. This is something that we do for every client we have. We custody at Charles Schwab. We also hold a beneficiary form ourselves, a copy of it on the client's behalf. Also recommend you downloading that same form yourself. Okay. What happens and what happened to Pam's, essentially her IRAs, her Roth IRA? Well, it passed to the estate. Why is this such a bad thing? Well, first off, they're subject to probate expenses then. They have to go through probate, which means they're open to the public, which means that an heir that you might not wanting receiving an inheritance may have a claim on that inheritance. Okay. The 10-year rule, the rule that we talked about that restricts your account and your distribution rule, now turns into the 5-year rule. Okay, so it cuts in half when it passes on to your estate. This is a huge issue. And Pam's heirs had received a rude awakening when they found out they only had 5 years now to withdraw that money from those accounts. And then estate income tax rates apply as well. And we can see here on the right, estate income tax rates are higher increasingly faster. So they're condensed essentially. Notice that pulling $800,000 or $100,000 subjects this estate to a 30% tax rate. Okay, so rule of thumb: never let your IRA, never let your Roth IRA pass to your estate. Write that one down. Make sure your beneficiary forms are up to date. Make sure they're going to the people that you want them to go to. Never let them pass to your estate. Okay. So let's talk through a few classes of beneficiaries. The first one is an eligible designated beneficiary, an EDB. Okay. And again, who qualifies? The most common will be a surviving spouse. And they actually have a few extra benefits available. Again, we've already talked about this minor child of the descendant, individuals not more than 10 years younger, or chronically ill or disabled people. Okay. These people have beneficiary royalty, so to speak. The reason being is because they're still able to stretch an IRA. Okay. They have some stretch rules still available to them. Okay. Now, the reason they left this stretchability in is because it's no longer nearly as valuable anymore. Why? Okay. Let's say that you pass away and you have a minor child. Okay. Well, that minor child, their RMD updates to their age, which is great. That's the whole benefit of the stretch. However, once they turn 18, they're now subject to the 10-year rule. So at most, a minor child only has 18 years of stretchability, if you will. Individuals not more than 10 years younger. Let's say you pass on your IRA to a brother or a sister who's 5 years younger. Well, you might have been subject to RMDs. That younger sibling might not have, or at the very least, it updates to their age. So their RMD will be slightly less. Again, the stretch isn't that valuable anymore because at most they get a 10-year buffer of having less RMDs. That's it. Okay. And then chronically ill and disabled, again, how the IRS's and Congress's idea here is how long are they really going to be able to stretch that IRA if they're chronically ill or if they're disabled. So there is still some stretchability, nowhere near as valuable. Okay. So let's go through an example here. Just so we make sure we all understand who's an EDB and who isn't. So Carl, he's 85 years old. He passes away. He has a wife that's 70. Would the wife qualify as an EDB? Okay, the answer is yes. Surviving spouses do qualify. Okay, a son, 43. Okay, the answer is no. Son is not a minor, so they're not a minor and a descendant. So the answer is no, they are not an EDB. Let's say a granddaughter, age 16. Now they are a minor, but the minor rule only applies to children. Okay, so this is not an EDB. Now, Carl has a friend that he goes to the Y with, who's 80 years old, and he wants to leave him some money. Yes, this person would qualify as an EDB because he's within 10 years of Carl's age. Okay, so the wife would have some stretchability. The friend would have some stretchability. Son and granddaughter would be a different designated beneficiary. So what are the two options for EDBs? First one is stretching the IRA to their life expectancy. So Carl passes away. And just so you know, how you calculate out this RMD from this table is take your account balance and divide it by this life expectancy factor. Okay, so Carl would have to divide and would owe an RMD. Basically, that's he would divide his, let's say it was a $100 million IRA. His RMD would be $76,000. Okay. Now, if he passes his money on to Carl, let's say, actually, sorry, $1 million divided by 7.6, sorry, it would be 131,000. Okay. 131,000 that he would owe as an RMD. If he passed it on to Carl, or sorry, if he passed it on to his friend, we don't have a name for his friend, that person's RMD factor would update to 10.2. So this person would owe more like $98,000 instead. And so this person is able to stretch their RMD a little bit longer or stretch this account longer by taking a smaller RMD. Okay, so again, able to stretch based on their life expectancy. The other option they have is they can use the 10-year rule. If for some reason the 10-year rule is more beneficial to them, they can just use the 10-year rule. Okay. There are a few additional options for a spouse. The spouse gets is the beneficiary royalty of the EDB, if you will. Okay. This spouse, first two options are they can roll the IRA over to their IRA, or they can just retitle the name of the account. Okay, why would they do this? Well, let's go through this example. Let's say that Carl is 85, his wife 70. So Carl is subject to RMDs. His wife is not yet. RMDs will start at 72. So, whoops. If Carl passes away and this full account passes to the wife might want to retitle or just move that money to her account because she's not subject to RMDs yet. Okay. If she remains a beneficiary on Carl's account, she will have to take RMDs based on Carl's RMD table. Okay. So those are the first two options. Usually makes the most sense just for simplicity, first off, but then second, if the spouse is a considerably different age, it might make sense to retitle or roll the IRA over. Typically when the spouse is much younger. Third option is spouse can choose to remain a beneficiary on that IRA. So again, the wife could remain a beneficiary on Carl's IRA. Now, this one makes sense in that situation, but let's say the years were, or the ages were flipped. Carl was 70 and he passes away. The wife is 85. Well, then it might make sense to remain as a beneficiary because they aren't subject to RMDs yet. The wife would be subject when Carl would have turned 72. And so basically the RMD will be much smaller because the spouse inheriting is much older. And so the name of the game here, again, is try to position these accounts in a way where the RMD will be the smallest. Fourth option, let's say that the wife was a primary beneficiary, the children were contingent beneficiaries. And let's say the wife is set money-wise. She knows that she can make it through retirement and doesn't have a serious need for the money. Well, she can disinherit the account. She can basically say, I don't want the account. I don't need the account. Send it on to the contingent beneficiaries. Now she can't, well, I think we actually get into it. So yeah, she can disinherit a portion of the account or the entire account. Okay. Next, we'll be talking about a designated beneficiary. This will be the most common beneficiary that you pass money on to. And it would basically be everybody outside the EDB list here. Whoops. So people that don't fit this description. So basically you pass money on to a child as long as they're over 18 and not more than 10 years younger, which is hopefully obvious. They would be a designated beneficiary. See-through trusts also qualify for this status. So we're not going to talk too much about trusts in this presentation, but they would also qualify. And these people are subject to this 10-year rule that we talked about before. So same example, who is a designated beneficiary here? And it'd basically be the opposite for what we had before. Wife is not, friend is not, granddaughter is, son is. So both of these people would be subject to that 10-year rule. Okay. So again, gone over this category. We've gone over this category. They have some stretch benefits over here, 10-year rule over here. And then we've touched a little bit on the estate as well. If you leave that money to the estate, they're not subject to the 10-year rule. Instead, they're subject to the 5-year rule. So we want to make sure this doesn't happen. A charity, it's fine leaving money to a charity. And they'll distribute that money likely right away. So basically, charities are fine. Never leave it to your estate if possible. So splitting up an inherited account. Let's say that you have multiple beneficiaries on that account. Obviously, multiple beneficiaries are required to split that account and adopt their own inherited IRA. This is required by September 30th of the year following the account owner's death. Okay, so let's say in 2021, someone passes away. September 30th of 2022 would be the year that they need to split this inherited IRA. Now, there are some wonky rules that happen and some implications that can happen from not splitting on time. So again, horror story. Kathy's 70 in 2021, passes away, leaving her IRA account to her son, Joe, 50% of her IRA to her son, Joe, 50% to her favorite charity. Now, fast forward to January 1st of 2023. Charity has not been paid out yet. They haven't split this account up. So what happens? Okay, they were supposed to split it up by September 30th of 2022. They didn't. Now, because of this, Joe is required to adhere to the 5-year rule, whereas previously he could have been able to qualify for the 10-year rule. So this creates a situation where how much do you want to depend on your heirs essentially doing the right things, making sure they adhere to these rules? For some, it can make sense to split your IRA up before passing away rather than put the burden on your child. So what Kathy might have done when she had this plan, let's say her IRA is $1 million, $500,000 in one account, $500,000 in the other account. In one account, Joe gets 100% of the inheritance. In the other account, the charity gets 100%. Basically, steps past this splitting rule and makes it much simpler for Joe as well as this charity. Make sure that he is not subject to that 5-year rule. Okay, the other thing I want to note, before you were able to pass, you were able to pass the owner's account on to a child, to a grandchild, okay, and keep with that stretching ability. Now, basically let's say the second person in this process, the grandchild, is what's called a successor beneficiary, okay? So how does this work? Okay, the owner passes away at age 70. They pass money on to their son or daughter, let's say. That son or daughter is subject to the 10-year rule. Let's say that son or daughter passes away. The grandson or daughter is the successor. They are still subject to the parent's 10-year clock. So their clock doesn't reset. They are still subject to that same clock. So if this parent passed away within 7 years of inheriting, the grandson or daughter would now have 3 years left essentially to distribute that full amount or be subject to that 50% penalty. Okay. So we've gone through a lot. Let's work through a few examples and hopefully clear up any extra questions you guys might have. Again, I know the Secure Act made this stuff more complicated. Feel free to ask questions in the comments if you're not clear on something that we covered yet. So, example 1, Terry's 42. He inherits a $300,000 Roth IRA from his father that passed away last year. What rules is he subject to? He's subject to the 10-year rule. Okay, he is not an eligible designated beneficiary. He doesn't have the stretch rule. He has to distribute that full $300,000 Roth IRA within 10 years. Now, this shouldn't be hard because he isn't subject to any tax when he does distribute it, but forgetting to will subject him to a 50% penalty. Okay, so he is subject to the 10-year rule. Okay, Beth is age 10. She inherits a $100,000 IRA from her mother who passed away in a car accident. What rules must Beth follow? Well, first, for the next 8 years, she gets a stretch rule. Her RMD, her required minimum distribution, is going to be far less than her mother's might have been, or than anybody's might have been, because she's only age 10. So it's going to be based off her life expectancy table. She's not going to have to take that much from that IRA. Once she turns 18 and is no longer a minor, she's subject to the 10-year rule. Okay, so minors that inherit these funds are subject to varying rules depending on their age. Okay, example 3, Robert, age 75, passes away without a beneficiary form on his IRA. In his will, he specifies that all of his assets are set to split equally between his 3 daughters. What happens to Robert's IRA? Is it stretch rules or the 10-year rule? Okay, well, it's actually the 5-year rule. Okay, what will happen is it'll go through probate. Okay, his 3 daughters should get most of his assets minus probate expenses. Hopefully there's nobody contests it, but they will now be subject to the 5-year rule. They'll have to distribute all his full IRA within 5 years. Okay, again, because he left his estate, or I should say, because he didn't have a beneficiary form, it automatically is left to the estate. Number 4, Carrie dies, leaving her IRA to her 2 children, Ashley and Rachel. 11 and 19. What happens with her IRA? Well, Ashley should be subject to stretch rules. Rachel should be subject to the 10-year rule. However, because they inherited the same IRA and it wasn't split, okay? Because it wasn't split, they're both subject to the 10-year rule. This is why it makes sense to split your IRAs at time, depending on who it's being sent to. If there are different rules that each will have, split it up essentially. Okay. Both will be subject to the 10-year rule. Ashley won't have that stretchability. So we went through 4 examples here. Let's kind of round the corner and talk about building this beneficiary plan, what you should do. First off, I would say you need to have a conversation with either your financial advisor, or if your financial advisor has never brought this stuff up to you, I'd recommend having a conversation with a more qualified expert. I'm guessing if they haven't talked to you about the Secure Act, it's likely because they don't know that much about it. Okay. So talk to a qualified expert. There's a lot of different situations, questions that can arise with a beneficiary plan. First off, if you're giving it to your children, are each of your children, do they both have the same tax status? Okay, I doubt it. I'm guessing one of them probably makes a little bit more, one of them makes a little bit less. Okay, well, when you split certain accounts up, those children will end up getting different amounts. Okay, someone who has more tax room to pay taxes at lower rates will end up receiving more from that IRA than someone who already has a high income and will right off the bat be paying at higher rates. Also, if you plan to give an IRA to someone and a Roth IRA, those will obviously have different tax implications. Giving a $500,000 IRA and a $500,000 Roth IRA to different children, the Roth IRA person will end up ahead in a huge way. Why? Because they don't have to pay taxes. That traditional IRA, taxes need to come from it first. Make sure you set your primary and contingent beneficiaries explicitly. In fact, when we're done with this, I would recommend checking to make sure those primary and contingent beneficiaries are explicitly spelled out. There's percentages listed. Make sure that it's set up in accordance to your wishes. Okay. Potentially split IRAs and Roth IRAs in accordance to those beneficiary wishes. If there are going to be different beneficiary classes that you end up giving to, you might want to split those IRAs and Roth IRAs ahead of time. Okay, keep a record of your beneficiary form in your estate file. Make sure your advisor also has copies as well. You want to have multiple copies in case anything happens. And then finally, every time there is a tax law change, every time there is a life change, review this beneficiary plan. Okay, Secure Act obviously should have changed this beneficiary plan in some significant ways. Okay, if tax law changes, you might have a specific percentage that you want going to each child based on their current tax status. Okay, well, if tax laws change, you might want to then update that beneficiary plan. If you have a grandchild, okay, you might want to update the beneficiary plan for every grandchild that is born. Okay, if your primary beneficiary passes away, update that beneficiary plan and move the contingent to the primary and replace the contingent. Always make sure you have primary and contingent beneficiaries as part of this plan. Okay, we've already kind of alluded to some of these. There's some additional estate considerations that we'll probably cover in future Wealth Wednesdays. First is dividing up assets in the most optimal way. Okay, if you want your assets to be split equally to your children, splitting them up just very equally will not result in each of them getting the same amount. Okay, why? Because certain accounts have different tax status and even your heirs have different tax rates. Okay, you might want to consider those heirs' tax rates when you're deciding how to split up this inheritance. Other thing to note is the estate tax exemption is huge right now. Okay, it's something like 11.7 million for each person. So if you're married, you essentially get whatever that would be, $23.4 million as an estate tax exemption, meaning if you're underneath that, you don't owe any estate tax. Well, because of the Tax Cuts and Jobs Act, that is set to roll back in 2026. And it's basically going to be cut in half. So this creates a situation where if you have some serious assets and you're single, you might be above the estate tax exemption. And that carries with it a 40% estate tax right off the top. Okay, so consider that within these gifting, within these planning considerations. And then what happens if you want more control over how your money is distributed outside of your retirement accounts? A trust, okay? Typically, a trust allows you to have more control. You might want certain people not getting the money all at once. You might want it split up in installments so they can't just spend it all in one foul swoop, okay? So again, a trust is a consideration that you might want to think about. That's something, again, we'll host a Wealth Wednesday completely on that sometime in the future. But in summary, more than ever, building a beneficiary plan is critical to passing money efficiently on to the next generation. It's important to know who you're giving to and what the rules are under this new Secure Act, okay? Don't make the mistake of becoming one of the horror stories that we talked about. Whether that's naming your estate, not specifying who you want the money to go to, not splitting the assets up correctly, not titling the assets correctly. Don't make one of these horror stories mistakes. The last thing I want you to do is spend all of this time, spend all of this energy watching these Wealth Wednesdays, positioning your retirement into a perfect scenario where your money accumulates in retirement rather than minimizes in retirement. And then you get to a point where you make a simple mistake when you're passing money on to the next generation. And now the IRS gets the majority of that wealth rather than your heir, who you actually were working that hard for. Okay. So let us know if you have any additional questions on this beneficiary plan presentation. Always remember, you don't need more money. You need a better plan, and you need to make sure your beneficiary plan is set up in place to pass money on to the next generation. Thanks for watching. We greatly appreciate you guys coming in every week and watching these presentations. We love doing this. Have a great rest of the day. We'll see you later.